This lawsuit's taking a legit scam, setting precedents that's going to roll into what everyone else is doing on a day-to-day. If you don't think this is significant or impactful, even if you're not in Arizona, this is a huge movement towards more regulation on real estate investing.
This is a wake-up call to everybody who is buying houses on a bulk basis or marketing to buy houses on a bulk basis. I don't care if you're a wholesaler, fix and flip, whatever you are. This is a wake-up call. This is time to check your processes, procedures, paperwork, and do things with integrity.
Guys, welcome to this YouTube video here. I have a special guest, Jeff Watson. I'll explain who he is in just a minute if you don't know Jeff. Jeff and I have been friends for quite some time, I think. And Jeff is my go-to expert on all things legal and regulatory, I think, in the real estate industry. And like I said, I'll explain a little bit about what he's done for this industry and some of the big movements that you're a part of, Jeff. But the nature of this video here is to talk about something that's been, if you're in any of the blogs or Facebook pages or real estate groups, you've probably heard some buzz around this lawsuit in the state of Arizona and the attorney general filing this suit against a handful of flippers, wholesalers, real estate investors. Apparently, it's lasted 10 years, hundreds of homeowners, and millions of dollars. This is a full-blown scheme here, a scam that's been going on for years and years. And all of this is now coming out. This lawsuit really exposed it. I mean, I read all 81 pages. Honestly, Jeff, this is like, if you want to be a scam artist doing what they did, this is actually the playbook because they break it down in such detail as to what they did, even the scripts that they're using. And I mean, I was just blown away at the level and the amount of people, title companies, attorneys, door knockers, all these people that were involved in this full-blown scam to steal from homeowners, mostly in foreclosure. And so we want to kind of talk about this, not so much about the scam and what they did. I think there's always things like that, going on, and we're going to continue to see things come to light like this, but more so, Jeff, on how this is significant to everyday real estate investors that are out talking to homeowners, communicating, transacting, and the gray area that a lot of us, especially wholesalers, are crossing into, maybe unwittingly, maybe unconsciously or unknowingly, are doing some of the things that regulators are not going to like to see, especially with contracts and things like that. So I'd love to kind of dive into that. So again, Jeff, thank you for being with me. Let me tell everybody a little bit about you, and correct me if I get any of this wrong, but you are an advocate for real estate investing nationwide. You've done quite a bit in the state of Ohio. I think you've changed the laws in the state of Ohio 5 different times, some of that through legislative change. Now, the big one that I've been following that you've done is a national policy, and that was to protect the self-directed IRA. In fact, I remember following you as you've gone through that, and you literally were able to stop that from going through. That was a Biden policy, the Build Back Better bill, and that would have just completely annihilated the self-directed IRA industry. And that was a close one.
Oh, I'll tell you what, my good friend, dear friend John Heyer and I, we poured our souls into that. Thousands of people listened to what he and I told them to do. We pulled that one back from the brink of the abyss.
I mean, going to Washington, most of this like on your own dime, just to prevent this stuff from going down, that would be detrimental to real estate investing. For the past decade, you've been really going to bat at a national level, local level. I've been following a lot of what you're doing in the state of Texas regarding seller finance, and really scary. That would really hurt real estate investing tremendously.
And Jerry, I'm going to tell you, when we get the bill that I helped write, I helped a little bit. There were like 5 of us write this bill. When we get that bill introduced, I'm going to be reaching back out to you to tell your people it's time to make phone calls in Texas. We have a very good chance because of the people on the ground. We've got a very good chance, but it's going to take an overwhelming amount of public pressure on members of the Texas legislature to move that bill through and get it passed.
Yeah, and let's put your link in here, your Seller Finance Coalition, because one thing that I've noticed, Jeff, is every single voice matters. Like when we rise together and we reach out to our elected officials and we make a voice, sometimes we think, well, what difference will it make if I get involved? But I think you've proven that when people get involved, it makes a difference.
I'll tell you a quick story about that. Going back to, I was in DC, we were fighting to kill this horrible thing to happen to self-directed IRAs. And I'd had a very productive meeting with a Democrat member of Congress from the state of Texas. The last question he looked at me after the meeting, we're walking out, he looked at me and he said, "Are you telling me that if we agree to take this out of the bill, all of those phone calls will stop?" And I said, "Yes, Congressman."
Phone calls
He
from
said,
people that are calling saying they don't want this. Yeah.
they were being bombarded because, like I said, John Heyer built this amazing website and we were using it and gave everybody the phone
Hmm.
numbers, the fax numbers, the emails to just go after this. There was a select group of members of Congress we were going after. There were 8 moderate Dems, and this was one of those 8. He's still in Congress. He and I still work together. And he said, "Jeff, are you telling me if we take this out, these calls will stop?" I said, "Yes." It came out, call stopped.
Oh my gosh. So it matters. I mean, they were sick
It
and tired of
matters.
all of us real estate people calling them. Isn't that cool that we can make a difference like that?
It is. It
And it
is.
takes
It's
everybody. You know, Jeff, one of the concerns I've had flipping back over to specifically wholesale real estate, and you have a lot of experience in this area. I've said a few times in the past few months that I don't know if our industry is salvageable. I don't know if we can rehab wholesale real estate, meaning there's such a negative perception in the marketplace outside of us wholesalers that wholesaling is predatory, it's harmful, it's this idea of equity theft and all these ideas. And we've done such a poor job as an industry to organize and have a voice and create best practices. And because of that lack of organization, we've let some of these NAR and some other people kind of run with this narrative that's been very detrimental to us. And I don't know if there's a way back, but you give me hope that there is a way back. Like, I think if enough of us can get together and really have a voice, maybe we can make an impact and change that perception in the way people interact.
It really comes down to this. You and I both operate from some core fundamental values of we are going to act with integrity. We are going to give as good as we get. We're going to be a true capitalist. I'm going to give you something for in exchange for something I want more. And you're going to do the same thing on the other side of that transaction. If we do business that way, we'll be fine.
Yeah.
But when we brag about how we carefully cherry pick lists of people that are struggling and under pressure, we use our carefully scripted NLP language to trigger an emotional response, and we high pressure them. And we're going to get into all that. I know we are. And we high pressure them into signing something right away. And then we won't let them rethink about it. Boy, we're putting a bullseye on our back.
Yeah.
I've had, in the last 6 months, I've had 2 investigative reporters call me and interview me as background on these kind of practices in different parts of the nation.
And then on top of that, let's make it elderly or make it
Oh, yeah.
pre-foreclosure. I mean, you're asking for it.
You absolutely are. But here's the point I want to make. I want everybody to understand this. I believe that wholesalers, when doing business correctly, provide a very valuable service
Mhm.
in the real estate economy. But when doing business the wrong way, they are a predatory, blood-sucking leech
Mm.
that give everybody else a toxic
And
taint.
unfortunately, due to the nature of it being a fast transaction and low barrier to entry, we do attract the bad actors. We do attract the people that want something for nothing, don't want to put any skin in the game. They want to just make a bunch of money really fast at the expense of someone else. We tend to attract that person. I thought, Jeff, let's start out here. Let's give everybody a bit of a summary of this lawsuit. And I'll put the link to the PDF where you can actually read this document. I thought it would be like tedious and boring. I was actually fascinated. It was like reading I just couldn't believe it. I'd read the next paragraph and I'd be like, oh my gosh, they did what now? Who was involved?
Uh,
The title company, the attorneys, like what in the world? It was an
I,
elaborate scheme that was going on for 10 years.
so I'm going to spoiler alert here, okay? If this goes to trial, I want to be there in the courtroom because there's some stuff that I think is going to be very interesting, straight out of a John Grisham novel.
Mm-hmm.
That's all
Oh
I'm going
yeah.
to say. It's
Yeah.
going to be some very
Wild
interesting
stuff
stuff.
that went down. So let's break this down here. First of all, the way that they relate to this scheme is they call this an equity stripping scheme. And I find that fascinating. The only other time I heard of something similar was when Atlanta passed their regulation there, the city of Atlanta, they called it equity theft. So very similar idea. Now they were specifically talking about wholesalers, but it's the
Yep.
same sort of idea. which is this idea around you're going to homeowners that have equity in a property and you're stripping them of that equity. So it's a
Okay.
very detrimental term to use.
It's out of the progressive liberal vocabulary.
Yeah.
And it comes from the mindset that the seller is a protected consumer
Mhm.
who doesn't have the ability to make a rational decision for what's best in their current situation. But we also see some really aggressive, abusive, bad acting by the people named in this lawsuit.
Yeah. But if we just take the idea there and isolate it, let's set this scam aside for a second.
Okay.
When you say this is sort of a liberal idea, the reason why is because what you'll hear a lot of the regulators and consumer protection agencies say is they treat the seller like an unconsenting party. And it's just not true. I haven't been in one single transaction where the seller wasn't fully aware of what they were doing, what their options were. They knew they could talk to a real estate agent. They knew how to look up value. Like they knew all the things, but they wanted that convenience and speed of a fast cash offer. And so they took it. So this
Right.
idea, this narrative that somehow wholesalers are stripping equity or stealing equity is a really derogatory, detrimental term that does not define what we do whatsoever.
There's multiple layers of political influence and bias just from that alone. I wish I could say more, but I'm not able to,
Okay.
given other considerations that I have.
Yeah.
But there's some political motivations behind this lawsuit.
Yeah. Okay. Well, I
Okay.
mean, that's good context though, because we know there's an agenda here too with some of it.
Oh, there's more than one agenda here.
Yeah.
Yes.
Yeah. And so
Yes.
guys, think about this. This lawsuit's taking a legit scam, setting precedents that's going to roll into what everyone else is doing on a day to day. So, I mean, this is, if you don't think this is significant or impactful, even if you're not in Arizona, this is a huge movement towards more regulation on real estate investing.
This is a wake-up call to
Mhm.
everybody who is buying houses on a bulk basis or marketing to buy houses on a bulk basis. I don't care if you're a wholesaler, fix and flip, whatever you are. This is a wake up call. This is time to check your processes, procedures, paperwork, and do things with integrity.
So let's go here, Jeff. Let me summarize this. Here's what I gathered reading through this whole thing. What they would do is they would knock on pre foreclosures that had equity. They would lie and deceive the homeowners that they're a charity and that they would catch up the back payments and they would help them stop foreclosure and keep their homes. Then homeowners would sign extremely biased contracts, even agreeing to transfer the deeds at significantly lower values. And that's where they get this equity stripping idea. They would create fake bankruptcy and probate filings to delay the foreclosures with the lenders. They would cloud title by filing memorandums. They would do liens. And again, sometimes they would transfer the deed to new companies. They would get title insurance. Then, if the homeowners refused to go forward, the defendant's lawyers would file lawsuits to force the sale by getting default judgments. Then they would evict the homeowners and flip the properties at fair market value, profiting millions of dollars. Did I summarize that okay?
That's the summary of the accusations made by the Attorney General.
Okay.
And I can tell you not all those accusations are true, but I can also tell you there's enough of them that are that should give every one of us great pause.
Yeah. And if you go through that 81-page document, I mean, one of the things that they did was they cited several examples, quoting conversations with title companies, lawyers, homeowners. They definitely did their homework and gathered a lot of information with specific deals.
They did. They also omitted certain things. Unfortunately, I can't talk about what they omitted. They omitted stuff that is contrary to what they're saying.
Yeah. I mean, there's
And
two
so
sides
there's
to every
going to,
story, right?
oh, yeah, this was their best shot. This is their opening. This is them showing up with their tuxedo
Yeah.
perfectly pressed, shirt ironed, hair groomed, the whole
Yeah.
bit. And you're not seeing the gaping hole in the bottom of their shoes and other stuff.
That's good to know. I know you can't talk much about that, but
Yeah.
that's good to know because when you read through this, you're like, they got these guys nailed so hard on all these things. But again, I mean, you're getting one side of the story, not the other
Yes.
side.
But it's an instructive one side.
Yeah.
Okay. I'm going to tell you right now, there's things that they've alleged in that lawsuit they're not going to be able to prove. I wish I could elaborate more, but I can't. I've been asked not to.
My big takeaway though, Jeff, is like, if they're coming out and they're saying, we don't like how you say this, how you do this, I want to go through these like 12 counts of fraud. Now we can all reflect on this and say, well, am I crossing into that gray area at all? Even 10%, 20%? If I am,
Yep.
how do I not do that so that I can have my nose clean and not be anywhere near the gray area?
Right. And I think that's going to be very instructive for our conversation to do that, because there are things that I see investors doing all over this nation that really scare me.
Let's
You
go
know,
through these because I think we could address each of these. So in this suit, Jeff, they did 12 counts of consumer fraud. So they took things they were doing and they said this falls under the Consumer Fraud Act, and then we want to pursue the maximum penalty for these things. And so maybe some of these things are far-fetched a little bit, but I think we can glean on each of these. First one is affidavits. So memorandums. Explain this, Jeff. Why? And we're starting to see a lot of states come down hard on memorandums. A lot of wholesalers do memorandums. Why is this an area that's very dangerous?
it's incredibly dangerous, and I really, really dislike it when an affidavit or memorandum or something or notice is filed clouding title. I really dislike it.
What is it that they're doing? Why are they doing that?
So they're engaged in a process of putting something on public record that impairs the seller, current owner's ability to convey title, to transfer legally in an insured, structured transaction with a licensed title company saying, yes, we can underwrite the deal. We can verify that we have a ready, willing, and able valid seller conveying to a ready, willing, and able valid buyer. What we see happen is, and this is the part that really disturbs me, is I see a lot of uneducated or undereducated, arrogant wholesalers put a property under contract and then go cloud title right away.
Yeah.
Now, if you're going to do that, at the same time you go cloud title, go put the purchase price on deposit with the title company and leave it there so that you can prove that you are ready, willing, and able to buy on the day you clouded title, and leave that money there. Leave it there.
No one's going to do that.
Then don't cloud title.
Yeah. So the argument people make in the wholesale industry is, and I've had this happen, is, well, I'm protecting my interest because I don't want the seller to backdoor me to my buyer or sign a contract with another wholesaler for a higher amount. So I'm going to go cloud title, prevent the seller from selling.
And the moment they tell you they don't want to do business with you, then let them go.
You got to let them go.
I've got too much stuff on my plate to do business with people that don't want to do business with me.
Yeah.
Let them go.
Yeah.
We're here for the long term. I want to use every transaction to build an ally, to build a referral source, not somebody that is going to blackball me and complain about me for the next 10 years.
I mean, guys, no one likes getting backdoored. That sucks. But I'll tell you what, what's the trade-off? You file that memorandum, you're running the risk that that seller that's elderly or in some sort of distress is going to go public. And the minute they get loud, you are always the bad guy. There isn't a story you can come up with where you're going to look like you're legit. When that seller says, I can't sell my house because they clouded my title and I want out of the contract and they won't let me, you're never going to look good. It's just not worth it. Let it go.
Yep.
Okay. Second one that they did they accused of was recruiting.
A couple of things going on here. Okay. They had a very sophisticated system. They were scraping data and trying to have a door knocker knocking on the door within 20 minutes of it being posted on public record that the house was going to an auction. But they're all using independent contractors. Now, folks, I got to tell you, they're not an independent contractor if they've got to meet those criteria. They're an employee.
Yeah.
So the IRS is probably going to get some leftovers on this one. Look out.
Oh, yeah. W-2 and a 1099, right?
Correct.
Yeah.
When you have people working for you that you tell them what they have to do and when they have to do it, and how much they have to do, they're an employee.
Yeah. If it looks like a duck and walks like a duck, it's a duck.
And so if you're using bird dogs, think about that. Are they now going to be employees if the IRS comes after you?
The sniff test is, do they work a set amount of time? Do you tell them what times they work? Do they submit an invoice? Do you give them a specific amount of pay? If they fall under those things, they're an employee. They're not a subcontractor.
Right. Here's the other one. Every state has this. If you're compensating an unlicensed individual upon the closing of a real estate contract or closing on a real estate transaction for their participation in bringing you the deal, that's against the law. That's
That's
you're
called
compensating
unlicensed
for
brokering.
exactly.
That's called unlicensed
Yeah.
brokering, and that's illegal.
Yeah.
Yeah. I mean, most people don't realize that bird dogging in and of itself is illegal activity because that's unlicensed brokering because they're getting
Yes, it is.
compensated for being a part of a transaction and without a license.
And they were unlicensed. They were not a party named on the contract to buy and sell. Yep.
Yeah. Yep. So guys, these are all areas that you may be doing right now that could get you in trouble.
Jerry, I'm going to tell you right now, there's already people who are going to be watching what we've had to say so far, and they're going to say, "Oh, but they'll never catch me."
Oh, yeah.
Oh, guess what? Pay attention here, people. I have seen multiple instances of investor B being unhappy with investor A and having investigators go to
Mhm.
those sellers that A was foolish enough to identify in their public filings. You're one disgruntled competitor
Mhm.
away from having somebody blow a whistle on your shady business practices.
And honestly, Jeff, in our industry with distressed real estate, a seller's number one decision isn't price. It's their certainty that you're going to perform. So if they're willing to backdoor you, more than likely you haven't done a very good job helping that seller feel good about working with you.
You have failed to build trust.
Yeah. And that's why you're getting backdoored. I don't ever get backdoored. I don't even know why it's something we talk about because I try to do a good job of building trust with the seller so they don't have a reason to go with somebody else.
I've had sellers contact me. I'm calling you about selling my house. And I ask them, have you spoken to anybody else? And they'll say, oh, yeah, I've already got it under contract with somebody else, but I'm calling to see if you'll give me more money. And that tells me two things. Number one, that buyer didn't do a good job. And number two, I'm wrapping this conversation up right now.
So this next one, Jeff, is something I try to talk about quite a bit because it's just around this idea of fraudulent acts, and they include in there deceptive, false pretense, false promises, misrepresentations. And one of the things that I see quite often, at least in previous regulations that I've read about, is they talk a lot about intent. And this is fascinating to me because when I see the wholesaling community, what they'll say is they'll say, when I talk to the seller, I'm the buyer, but later I change my mind and I decide to wholesale it. So I don't have to tell the seller that I might wholesale it because how does anybody know what my intent is? My intent is to buy the house. Well, there's a very clear way that they can define intent, and they're going to look at your past behaviors to define your intent. So if you've never actually bought a property, you've only ever done assignments, you don't own rentals, you've never flipped, you just do assignments, you can't say my intent was to buy it when you don't have the money in the account, you don't have the financial backing, you've never done it previously, all you've done are assignments, then your intent is never to buy it. Your past behavior tells your future behavior.
Exactly right. I've preached that for so many times. It's going to be your behavior, and you have the capacity and the ability to perform. Do you have the money or do you have access to the money
Mhm.
when you're inking the contract? Then I believe you might have the intent. Now, if you've bought property in the past and you've actually closed on it and taken title and you got the money in the bank for what you're offering to pay for this thing, oh, you got a strong case to prove you had the intent to buy. But if all you've done is assign, and you're broke as a joke and you got no lines of credit and you got no private lenders in the back pocket, don't tell me that you had the intent to buy.
Yep.
I can't believe it. And you're basically perjuring yourself under oath.
Yeah, you're going to lose
Yeah.
that argument. You know, I know a prominent educator in our space. Here's what they say about like South Carolina passed a pretty aggressive law around wholesaling. They say, look, they're not going to enforce it anyways. So what are you worried about? Just keep doing it. Prominent educators saying that.
Here's what they're telling you. Here's what they're telling you. I'm an anarchist. I don't believe in laws.
Mhm.
And I want you, as my student, to go do these deals contrary to law. And I want you to recruit either title companies or closing attorneys to break the law with you. Licensed professionals have a career on the line with families to feed,
Mhm.
employees to support. I want you to entice them to break the same law. That is grossly irresponsible and unacceptable.
Just because I can rob the bank and get away with it doesn't mean it's okay.
Here's the problem that short-term thinking leads you to. It leads you to 10 years of reckless behavior doing real estate deals, hundreds of transactions, lots of injured parties, and finally, you now have a major law enforcement agency coming after you saying, we're going to claw back all the money you ever made doing
Mhm.
this stuff.
That's the risk you run. It's not worth it.
I'm going to go out on the limb. I'm going to just say this. If every state in the nation would do what South Carolina did, I'd be thrilled. I'd be thrilled. And here's why. I have clients that wholesale in South Carolina,
That are killing it now.
and they're killing it now.
Yeah.
And here's what they've discovered. This is shocking, but I knew this. I've been telling them this for years because my other clients in other states have discovered the same thing. You mean when I buy it, when I pay cash and I close and I take title, I have more time to market it and I get more market exposure and I
Yeah.
find a buyer who will pay me more than what my assignment fee would
Yeah.
be?
Yeah, Jeff, the biggest change I've made in my real estate business in the past couple of years is wholetailing, or I like to call it takedown, which is just buy it and resell it. Buy
Yep.
it, close on it, take title, get the funding, turn around and resell it on the open market. You're going to get a higher price. You're going to make more money. No one's mad at you. You fulfilled everything you said you would in the contract. Just good old
Yep.
fashioned real estate.
Here's the part you may not know this. One of the leading regulators of that kind of activity in the state of Ohio, a woman that has a lot of influence across a lot of states, looked at me one day and said, if they buy it, we don't care what they do with it afterwards.
It's when
Yep.
we're trying to transact before we own something that everybody has a problem with.
So then I'm going to dispel a myth that somebody's going to come at me with. They're going to come at you and I with this. I'm going to dispel it right now. I've been personally involved in transactions in South Carolina where the cost of money was expensive to fund the takedown,
Mm-hmm.
but they still made more money than they thought they
Yeah.
would have going to made on a
Yeah.
$10,000 assignment fee.
What we're finding, Jeff, is we're making 2 to 4 times more by buying it and reselling it on the open market than doing the assignment.
Yep.
I
So
mean,
I've got a question. It's a rhetorical question for you, but everybody else in the audience needs to hear this. Do you want to work with less stress, do fewer deals, and make more money? Or do you like to be the hamster running on the wheel, running faster and harder and get less money for it?
yeah. Option A every time. This is what I keep telling everybody. What you just said there is the future of wholesale real estate. I think in time, the assignment of contract is going to get harder and harder and harder, and it's going to get frowned upon more and more by regulators, and it's going to, in essence, go away or become extremely non beneficial to do. That's my prediction.
Yep, I agree. And so just imagine, let's just jump forward, okay? Let's just imagine you're meeting with a seller and you pull out your iPad or your laptop and you go to the county records office and you go, hey, I know you're concerned about whether or not I can perform. This is the name of my company. I want you to see on the county's website all of these houses I've bought in the last couple of years.
You're going to beat out every other wholesaler you're up against if you could do
Yep,
that. I mean, it's just the
exactly.
way it's going to be. Okay, so Jeff, let's go through a couple more of these. The other one here, number 4, count number 4, they called it omissions. And this one was specifically aimed at wholesaling, and it was not disclosing to sellers that you intend to wholesale. And that's a big no-no. In fact, Arizona passed a law that says you have to disclose that you're wholesaling. So they
Yep.
got them nailed on that one. If they're not disclosing that, and I think whether your state requires you to do this or not, this is, by the way, a big thing in all of these regulations with wholesaling is proper disclosure. And real estate agents, I mean, they all know if you're a licensed real estate agent, disclosure is like the number one thing they hammer on you every single day is proper disclosure, proper disclosure. So like wholesalers, you have to explain to that seller, hey, I may not be the end buyer. I may end up assigning my contract to somebody else for the intent of making a profit. You have to explain that and make that clear to them. Even if you might end up buying it or whatever, if there's a remote chance that you might assign it, explain that to the seller. Help them understand that. Why is that so
One of the
important, Jeff, that they have
it's
disclosure there?
because you need to make sure that both parties really have a mutual meeting of the minds to have a valid contract. And so if you're telling me that you're going to buy my house and you're not telling me what you're going to do with it, do I really know if I want to sell to you or not? But if you tell me you're going to buy my house, you're going to move into it, you're going to fix it up, it's going to be yours, great. You tell me you're going to buy my house, you're going to fix it up, and you're going to rent it to somebody else. Great. But just tell me.
Yeah.
Just tell me. But the beauty of it is this: when you disclose it in writing and you get their initials and a date by that disclosure section, there's nobody that's going to come back around from an AG's office or an ambulance chasing law firm or wherever, and they're going to say, oh, you didn't tell them what you were going to do. You're going to go, it's in writing. I did.
Yeah. What I do, Jeff, is I have an entire clause that explains it in my contract. And I make sure that I verbally review that with them. Even if they don't have any questions around it, I say, look, my goal is to make as much money as I can. Here are some different ways that we do that. And I can legitimately back every way that I mentioned because I actually do those things. Like, don't say it if you don't do it. You know, that goes back to what we talked about. But like, you think you might lose the deal if you tell them you're going to wholesale it. What I found is they actually trust you more because you're being honest.
Shocking, yes.
So that was called omissions. Number 5 was void contracts. Now they hit on this one really hard again and again and again. In their contracts, it said, at any time, buyer has the right to cancel the contract for any reason, but seller cannot cancel the contract whatsoever. They called it a lack of mutuality. Now, what does that mean, Jeff? What is a lack of mutuality?
So you don't have an even match of mutual obligation. We're under contract, but I can back out at any time, but you never can. So that's the problem. If you are not putting down material, significant earnest money, and if you are using lopsided contracts that are homebrew, that you've not had the time or not had the inclination to have a good local real estate attorney to look at, then you're part of the problem.
Yep.
You're part of the problem. I tell people, listen, yes, you need to put down earnest money, and it can't be $10. It can't be $100. It needs to be $500. Where did I get that number from? Meeting with multiple regulators from multiple states. That was a number I could finally get them to go with.
Okay.
And you have to understand, earnest money is to compensate that seller if you fail to perform.
I call it the seller's insurance policy. You're going to be good on your contract.
And here's the other thing that gets me. And Jerry, it's all through this Arizona lawsuit. If you've got absurd weasel clauses in your contract to get out as the buyer, and you don't have anything that looks somewhat equitable for the seller, you're just starting down the bad road. But here's where it's going to get interesting. This is where the battle's going to be in the trenches, because I have a couple of questions. How different is that language from the typical real estate agent contract language used in agent sponsored or managed deals in the state of Arizona? First question. Second question is, have these contracts ever been already litigated in a contested manner in the state of Arizona? I suspect this is where the AG is going to run into a roadblock. They're going to have a problem here. But I don't want to miss the point. If you've got a bunch of weasel clauses in your contract, I have no opinion of your contract whatsoever, except that it's junk.
Where it happens, Jeff, is with the inspection contingency.
If my inspection reveals repairs previously unknown of X% of the purchase price, I have the right to back out.
How do you dispute that? That's fair.
Yeah.
That's just fair.
Yeah.
I think the other one, Jeff, is a time frame. Like, an inspection contingency should have a reasonable time frame. And I think they're going to look at that. 5 days, 7 days, maybe 10 days.
Then that contingency needs to be waived or released and so on. I mean, if we're professional house buyers, we need to be as professional as real estate agents are.
So guys, if you have in your contract right now, inspection contingency all the way up until the day of closing, that is a weasel clause. That is designed to give you a way to back out of that contract. All you have to say now is, due to my inspection of the property, it doesn't meet my standards and I'm out. And that's going to look really bad on you if a regulator looks at that or a litigator looks at that.
But at the same time, and I recommend this, reserve a walkthrough clause that says, listen, I can walk through the property the day before closing, and all of a sudden I discovered that in the windstorm last week, this tree that was standing upright is now leaning on the roof of the garage. Hey, that's material.
But that's a legitimate reason, right? We're
Correct.
talking about weasel clauses here that people use.
Oh, I agree. But I'm explaining why you need to have both an inspection clause and a walkthrough clause. Yeah.
I think too, Jeff, another way that you can get to the bottom of this is what's your contract fallout rate? I mean, Jeff, I know wholesalers that close 1 in 10 contracts. That is horrific.
Do they have any idea how they're going to get roasted
They're going to get
in an investigation?
I mean, guys,
Oh,
there's normal fallout rate, like, because we're talking about distressed real estate. I don't think it should ever be more than 20, 25% of contracts that don't make it to the finish line. And for a title issue, not because you backed out.
yeah. Fallout rate for title issues, fantastic. That,
Yeah,
whatever. I
yeah,
have
it is what it
no
is.
qualms. Fallout rate when the seller changes their mind, it is what it is. Let it go. But just to arbitrarily, oh, I don't have the money, I'm not going to close, or no, I couldn't find somebody to assign this, I'm going to walk away from this.
That looks
And
really
then
bad.
the one that gets me the most is I'm gung ho as a wholesaler for like 60 days. I put a bunch of properties under contract. Some bad coach taught me to go ahead and file affidavits. And then after 60 days, I give up. I don't pay attention to that email account anymore. I turn off that cell phone, the whole bit. And when somebody tries to find you to remove that cloud on title, they can't. You are the worst kind of the worst kind.
Because you're preventing them from selling the home, and that's financially hurting somebody
Yep.
tremendously.
And
Yeah.
so when they find your LLC through the statutory agent and they sue you, I hope they light you up.
So the whole point here, guys, is you have to be fair. Like, what you're doing has to be fair. It's so funny, Jeff, because this is the argument I made when I did a video recently about earnest money, and I said I find it fascinating that wholesalers will pay a $10 earnest money to a seller, but then when they go to assign their contract, they get a $5,000 non-refundable earnest money because they want to make sure that their buyer performs. So let me get this straight. You want a double standard. You want to not be able to perform with the seller, but you want your buyer to make sure that they perform. Do you see a problem here, guys? Do you see how that's not consistent?
I mean, that just screams lack of integrity.
Yeah. If
Yeah.
you're going to mandate your buyer gives you a non-refundable significant earnest money, you better be willing to do the same thing with the seller, or you lack integrity.
Jerry, I'm just going to throw this out here so the audience gets a perspective on this. Before the market cooled down, the number of wholesalers that I represented on an aggregate basis were buying 2 and 3 houses a day.
Mega wholesalers, I call those.
They had me on dial, they had me on a retainer. Together, they're averaging 2 to 3 houses a day in acquisition. So I understand the business, is what I'm
Yeah.
trying to tell people.
Yeah, you
Yeah,
understand how this all works. Let's talk about this one here. Count number 6 was foreclosure consultants. Now, I see this taught, and I see a lot of pre foreclosure people in the industry doing this, and this is really dangerous. But they're approaching pre foreclosures as consultants. Why is that dangerous?
you hit the radioactive hotspot for a couple of reasons, okay? Arizona has a pre foreclosure consultant statute. That's the word
Yeah.
used. It's not a good statute, it's not well written. The way it's being interpreted in this lawsuit turns the statute inside out and against itself. Other states like Colorado and Oregon, very similar in their progressive government mindset, have other statutes in companion to the foreclosure consultant statute, a foreclosure buyer statute. And so the question really is, and it's going to get litigated here, is a buyer a consultant? I don't think they are. A
Mm-mm.
lot of other lawyers don't think they are, but the attorney general in Arizona is saying they are. So it's going to be very interesting. Here's the huge takeaway for everybody. Doesn't matter where in America you live. If you are marketing to people who are behind on their payments, if you're marketing to people who are in foreclosure, doesn't matter if they're 31 days late or 120 days late or 4 years late, you have to make sure that you have to check whether there is a statute in that particular state, and half the states have them. And you better consult with an attorney that knows that statute in that
Yeah.
state, and you better govern accordingly.
I mean, one of the things on here, this was another one here, was unauthorized practice, financial exploitation. And some of these ideas were around like giving advice, telling them to do a bankruptcy, all of these things around we're consultants, we're experts in foreclosure. All of this is going to get them, it seems like, into a lot of trouble.
Based on what I see in the complaint, I don't think that they made up the fact that bankruptcy courts ruled what they did on these guys. Of you're filing false bankruptcy, you're practicing law without a license. Let's be very clear. And this is something that a lot of people are going to not like what I have to say. But you cannot give legal advice unless you're a lawyer. You can't fill out probate forms for somebody unless you're licensed to do so. You can't fill out bankruptcy forms for people unless you're licensed to do so. You can't tell them to go file bankruptcy unless you're licensed to do so. You can only tell them to contact a bankruptcy attorney or a probate attorney.
This is count number 8, financial exploitation of vulnerable adults. And basically, it's getting them to give them private or confidential information. Social security numbers, give me your bank statements, give me all these things. And I see a lot of foreclosure people in the industry getting all of that information from sellers.
Here's the challenge. We know it's going to be undisputed that people in foreclosure are under economic duress. It alters the way they think and process information. It affects the decisions they make. Add to that that the foreclosure may be the result of an illness, a divorce, a job loss, an injury. Now you've got two compounding factors affecting their ability to think and make decisions. And if you're going to work with these people, please, please get an independent third party professional to assist in some of these things. Because if they start trusting you and turning this stuff over and you do not act with a fiduciary duty for their interest against yours, when in doubt, it's for them, not you, you're setting yourself up for trouble.
This is the script I see over and over again. Don't say, my first priority is to help you stay in the home and keep your home, when you don't have a history of that. If you don't have a history of doing that, all you're actually doing is using that as a script to get in the door and help them feel comfortable with you so that you can somehow buy their property. That's dishonest. Don't say that.
Correct. And I mean, if you're going to say that, you better be prepared to stroke a check and catch them up in exchange for the right to buy the house in the future. So if you're going to say that, you need to be prepared to stroke a check to catch them up, to reinstate that loan in exchange for the right to buy the house in the future, which puts you at risk that they may go back into foreclosure again and you may lose that right. Is that a gamble you want to take or not? Then if it's not, don't say those words.
So then, Jeff, we won't touch on too many of these, but there was one called racketeering, forgery, illegally conducting an enterprise. I mean, this was really digging deep into the scam part of their business. But number 12, they called alter ego. And this was a technique where they were using different entities for every single deal. Where can this go wrong? I mean, they were using this to hide things and do transactions between other entities, tell people one entity when that was a shell company, all that kind of thing. But how can people do that wrong?
Here's what was going on. They were not operating these companies as separate, independent, legally existing entities. And so if you're going to use a new LLC for every deal, I don't know why you would, but if you're going to, then make sure you correctly set up the entity. Make sure you get a tax ID number for it. Make sure you sign an operating agreement. Make sure you sign all the other
Open a
stuff
bank
that brings
account.
the entity into existence. Make sure you document the meeting of the managers and members that brings the entity into existence. Make sure you keep corporate records, have a separate accounting ledger for just that entity. The money related to that deal goes into and out of that entity's bank account. But when you start slush funding it around and moving it from this company to that company by a check or whatever, you've lost the legal protection. The veil can be pierced. You're running without protection.
One thing I did want to touch on here, though, was title companies and lawyers all being involved. It appears that a little bit of greed set in because there was lots of transactions, so title companies were overlooking things.
You've got the responsibility of reading the contract and determining if it's a valid contract. And if you close a deal that we later on don't think is a valid contract, we're going to come after you.
See, this is the part that I'm glad you're talking about, because this is where I see this going really bad for wholesalers. When title companies now are worried about getting sued and they're worried about the legality of a contract, we're crossing into a whole nother realm here. You look at South Carolina, these are attorneys. They have their license on the line. And now the pressure is on them, not the wholesaler so much. It's on the attorney, the closing attorneys, that the state's going to come down on them if they conduct these transactions.
Lawyers and title companies have a professional obligation to do their job. When you read between the lines of this complaint, this attorney general is saying, hey, you had valid court orders that you obtained, but we think they were bad. Attorney general, you need to name the judges that granted these judgments. That's why I'm telling you, if this goes to trial, I want to be sitting there in the courtroom. There's some stuff there that fireworks going to go off.
Now, Jeff, how much money do you think is on the line here? Because there's all these counts. How's that even go down?
That is a great question. I would tell you that the main defendants in this case, and there's a handful of them that are clearly listed, and I'm not going to mention their names. These people are looking at tens of millions of dollars of potential risk and liability. Tens of millions.
Is there jail time here for them?
No, this is not criminal. This is simply civil.
Okay.
This is civil. There's no jail time, but there is the ability of clawing back all the profits they've made. There's the ability of imposing a fine that says you'll never do this
Yeah.
again, and we're going to put such a burden on you that we're going to shut you down from ever transacting in real estate ever again unless you're buying your own home to live in.
Yeah, it did say that they want them to never transact again, so they're going to try to do that.
And probably they're going to get that. There's stuff that the AG is definitely going to win in this case, and there's some stuff that I'm just not sure about yet.
But again, I think, guys, to wrap up here, the main point of why this is relevant to you and me and all of us is because there's more at stake here than just let's bust these scammers for doing, bad business. There's clearly a motive here to set some precedents that's going to turn into case law that will then be used to create new law and more regulation. This is just opening the door for some really strict stuff to come down the pipeline here in the future.
Bad behavior equals bad facts. Bad facts give us bad case law.
Because it seems to me, Jeff, that we don't get like fair regulation, we get over regulation is what tends to happen. Too far.
Oh, yeah. And I'm going to tell you, there's other AGs that are paying attention to this case. This is the last thing I'm going to say. People need to understand what this case is really about. Despite the headlines I've seen shared all over the place, this case has little to nothing to do with subject to transactions.
Yeah, you were going to talk about that. So why is that
Yeah.
significant? There were a couple sub 2 cases that they cited.
3 times they mentioned subject to out of 81 pages. This is not about subject to. This is about not doing business with integrity. This is about having a plan in place, a well executed business plan to high pressure sellers into contracts that you're not really performing on correctly. I mean, there's some issues here. I mean, one of the big battles in this case is going to be, were the contracts that were being used, were they valid or not? That's going to be a big fight.
Mm-hmm.
That's going to be a huge fight.
It's okay. Jeff, how can
Yeah.
people learn more from you? What's your big thing you're working on right now that everyone watching this can get behind?
There's a couple of things that I would love is, number one, go to my blog, watsoninvested.com, and sign up for my free email newsletter. If you want to do business the right way and grow and have long-term integrity, sign up for the email newsletter. The second thing is, this is where I'm really pushing right now. I'm really pushing on teaching people the right way to do business.
Okay.
The right way to do business, giving them the tools to know what they're doing the right way, and always, always, always giving them, hey, listen, here's a checklist to follow to find a good attorney in your area. In order to get my paperwork, you've got to agree that you're going to take it to your local attorney and have your local attorney review it and bless it and change it as necessary.
Because real estate is governed at the state level, state by state.
State and county level, yes. And so just because I'm licensed in Ohio doesn't mean my opinion is worth anything in any of the other 49 states and other territories of the United States of America.
Yeah.
I do a lot of stuff with IRAs, as we already talked about. Tax code that applies in all 50 states and territories.
Should people check out the coalition you're working on?
You know, the Seller Finance Coalition, yeah, if we can get that link up, that would be great, because we're going to be doing stuff, continue to do stuff in DC. We've already had some preliminary meetings in DC. We're going to get the bill reintroduced. And we've got this big fight that you alluded to in Texas. We are going to be on the ground in Texas. There's been about 6 of us that have really been carrying the flag for the Seller Finance Coalition in Texas. We're going to need hundreds of people to chime in and give us support.
I think I read, or maybe you told me, seller finance is like 20% or more of all transactions in the state of Texas. So it's a big deal.
20%.
Never think this doesn't apply to you, because every time these things happen, it opens the door for others to copycat it.
So the mortgage banking industry is trying to push through legislation that is going to eradicate seller financing in the state of Texas. 1 out of 5 deals will go away if they have their will.
Which hurts the seller. It hurts everybody. It doesn't help anybody.
Everybody in all across America.
Yeah.
Hurts everybody all across America.
We'll put that link in the description below as well. And thank you again, Jeff, for your wisdom, your insights. Thank you for being a voice for the industry. I love that you're not afraid to have the hard conversations about what's right, even if it's not popular, even if nobody likes it. You're willing to stand up and do the right thing. And a lot of this on your own dime, for just because you feel strongly that it's the right thing for our country, for our industry. And there's just not enough people like you out there advocating for us. So guys, leave a comment and say, Jeff, I really appreciate your hard work to keep investing alive and well and entrepreneurship alive and well in America, because it's no small feat what you do. It has made, and I know you will continue to make a massive impact going forward that we all benefit from.
Thank you, Jerry. And I'm going to just share two things. Last year, I personally spent over $50,000 of my money, my earned income. 50,000 went to political activity and engagement last year. And I'm now in a position to where I could be in the choir singing "Kill Corporate Transparency Act, stop this nonsense." And they listened. So
That's a
yeah,
big deal. That's
it's
a
a
big
big
deal.
deal. That's a big deal. I mean,
That means your influence is
millions,
reaching.
but we helped millions and millions and millions of small business owners in this country. It was worth it. I mean, while they were on the campaign trail, I asked influential members of the House of Representatives about the Corporate Transparency Act. I got a chance to go after a newly, not go after, but ask a newly elected speaker. I mean, not speaker, but United States Senator. I've had the chance to talk to the Speaker of the House on a couple of occasions. I mean, I'm getting the access I'm looking for.
It's super fortunate that we have a common sense administration that right now. So that helps too, I bet.
Oh man, oh man, oh man. And, I will. You're going to really understand this one. I bought a beautiful, beautiful condominium in Condado just
That's
in
Puerto
case.
Rico, everybody. Puerto Rico, yeah.
Yeah, just in case.
You're ready. Yep, you're ready.
And I just in case. And now I don't need it. I'm going to sell it. So if you know somebody who's looking for a beautiful condo in Condado,
I might. I'll reach out to you offline. Even though we left, I'm still actively doing stuff there. So, well, it's
appreciate
been
it.
a pleasure, Jeff. I love being able to have these high level conversations with you. Thank you so much. I'd love for you guys to leave a comment and say, Jerry, after this video, here's what I see that I'm doing that might be a little bit in the gray. Here's the changes I'm going to make so that I can operate with higher integrity, be an example, be the beacon on the hill that we so need in this industry. Make that difference one person at a time. If that's you and you want our industry to be around for a long time, raise your hand and say, I'm willing to do the things that we need to do so that we can preserve our industry, continue blessing lives, continue helping sellers, doing the right thing, building businesses, helping our families. Like, this is the only way we're going to survive this environment if we don't all come together and work together on this.
Correct. Absolutely correct. Yep. All right, man. Peace.
Thank you. Appreciate you guys. Bye.